Welcome back. This is the fourth meeting of the Bills Committee. We are looking at Clause 13 of the bill. Next to speak, Mr. Tommy Cheung. Chairman, as the DS explained, we referred to subclause 7 of unlawful drilling. May I ask the DS to explain clause or subclause 7 in the context of subclause 6? Take your time only when you're ready. Who will take this question, please? DS? Chairman, this is for clarity's sake. In subclause 6, we refer to two types of persons. One, those who have enrolled themselves in it, and also those who have made an agreement. And that is why in subclause 6 we provide the scenario capturing the acts involved, and then we provide the time frame or the time limit in subclause 7. Mr. Holden Chow. Thank you, Chairman. In the UK, many schools provide CCF military school, and I also joined the CCF training. I was when I studied in the UK, I was taught how to disassemble or take apart a gun. Now I think this targets what's happening here. It's all right for a student studying abroad to receive this kind of training. Now, when these students come back to Hong Kong, these students may want to further this kind of training. They want to gather themselves together based on the training received abroad. Then shouldn't they make an application to the authority in Hong Kong? These students are in boarding schools in the UK, and then every summer when they return to Hong Kong, they may wish to have further training on this skill. I just want to know whether this scenario will be included. Yes, as Mr. Chow puts it in subclause 5, we refer to those doing it abroad with the involvement of an external force. Now we can take a look at 13.1 and 13.2. Exemption is provided in subclause 5, but they do not apply to something that happens in Hong Kong. So if this gathering takes place in Hong Kong, they should seek permission from the Commissioner of Police or the Secretary for Security. All right, it is important that this requirement is known. Dr. Loy Kwok, I have questions on subclauses 6 and 7. DS just explained a transitional period of 6 months. That is, you considered the summer break. You want to reassure parents who have arranged for their children to take part in certain training or drilling abroad, and that they will not be caught inadvertently by the law. What about some, genuine unlawful drilling? Why should they be allowed a 6-month transition? Because I feel that they should be stopped immediately. How do you strike a balance? Yes. We understand the dilemma presented by Dr. Loy Kwok, and we need to consider how many people are involved. As the matter stands at the moment, we believe that only a small number of people will be receiving training of this sort abroad. But if this is to take effect immediately, it is going to affect a large number of citizens, and that is why we take this approach. Let's say if unlawful drilling takes place with an ill motive, then even with this transitional period in place, you can handle these situations by other means. Yes, we will keep in view these situations. Mr. Tommy Zhang. Part 2, unlawful drilling. This is the part on treason. Mr. Stanley Ng referred to drilling for color revolution. As I understand, part 3 is the part that deals with color revolution, insurrection. So will unlawful drilling in any way affect how this is to be interpreted? As far as the law is concerned, I don't think this will be the case. You referred to the Hong Kong version of the color revolution in 2019. At that time, a lot of things happened. Well, there may be certain acts of insurrection, unlawful drilling, and using a computer or electronic system endangering national security, which may contravene the various provisions in Article 23 of the HKNSL. Yes. Seeing that there are no other questions, let's move on to Clause 14. Extraterritorial effect of this part. Subclause 1. If a HKSAR resident who is a Chinese citizen does any act outside the HKSAR, and B, the act would have constituted an offence under Section 10(1) had it been done in the HKSAR, the resident commits the offence. Clause 10(1) refers to the offence of treason. And then subclause 2, if any Hong Kong permanent resident, body corporate that is incorporated, formed, or registered in the HKSAR, or body of persons, whether corporate or unincorporated, that has a place of business in the HKSAR, does any act outside the HKSAR, and the act would have constituted an offence under Section 13(3) or 4. Had it been done in the HKSAR, the resident or body commits the offence. And then if we go back to 13(3) and 4, as discussed before, they refer to offences of unlawful drilling with the support of an external force. Here, under subclause 3, we provide a definition for HKSAR resident, which means a Hong Kong permanent resident or a person who is qualified to be issued with an identity card under the Registration of Persons Ordinance but has no right of abode in Hong Kong under the Immigration Ordinance. Questions, please, Mrs. Regina Ip. Well, I wanted to ask this question, but Mr. Lai next to me just gave me an explanation, so I'll withdraw my question. Dr. Kennedy Wong. A drafting point. 14(2)(a)(3). Body of persons that has a place of business in Hong Kong. I don't think this refers to a business registration. Now, for the Chinese characters, 業務地點, it should be called place of work or place of operation, because place of business seems to refer to the business sector.
We thank Dr. Wong for his comment. We have made reference to similar provisions, such as that under the Crimes Ordinance, body corporates with a place of business in Hong Kong. Place of business is usually used as the equivalent for the Chinese 業務地點, so we think the Chinese term and the English term do tally. Ms. Carmen Khan. Thank you, Chairman. 14(1). This has to do with treason under 10(1). So this has to target just an HKSAR resident who is a Chinese citizen. So now my question is 14 subclause 2. Who takes part in the specified drilling or providing the specified drilling in collaboration with external forces. So 12.2a1. This is just about the Hong Kong permanent resident. Why put it like this? Are we having too narrow a scope? Why not just say a Hong Kong resident? HKSAR resident is defined as a Hong Kong permanent resident, and B, it doesn't matter whether this person has a right of abode. As long as this person has the Hong Kong identity card, this person is on the hook. These people may break the law overseas. Why not cover them when they break the law overseas? DS, please. Now for unlawful drilling, the law is there to prevent law breaking. Now, we don't want to have people receiving training overseas. They're drilled overseas on offensive tactics and then they come back to Hong Kong to commit a crime. We don't want that. So, on the part about unlawful drilling, for people who can return to Hong Kong, they are Hong Kong permanent residents. That's why we include Hong Kong permanent residents. Ms. Khan's point is that whether we should also cover people with a Hong Kong ID card. So expanding the scope, not just permanent residents, but also other residents of Hong Kong. Broadening the scope to Hong Kong residents would mean we would have a much wider scope. There are many people in this category. So that will mean many people would be covered. But do they pose huge national security risks? We decided to strike a balance. We decide to play safe. So we simply target Hong Kong permanent residents for the extraterritorial effect, and that's a balance we have struck. Chairman, there are exemptions under subclause 5 for cases that warrant an exemption. So shouldn't we give thought here? Some people have yet to earn their permanent residency. They may exploit this gap. So someone who has yet to become a permanent resident of Hong Kong, as the DS told us, there are many such people. These people may provide drilling overseas in addition to receiving. Few will receive drilling, but these people may provide drilling overseas. Non-permanent residents of Hong Kong may provide specified drilling overseas. We should look beyond just whether these people will return to Hong Kong. Just then the DS said permanent residents are more likely to return to Hong Kong. Whether these people come back and whether we can catch them should be a secondary consideration. The first question is whether we should criminalize, whether we can catch this kind of criminality. That should be the primary focus. DS? Mr. Ivan Leung, if I may assist, I thank Ms. Khan for the point she raised. In coming up with the extraterritorial effect for unlawful drilling. Now, say you have a non-permanent resident. They receive unlawful drilling overseas and they come back to Hong Kong. To deal with that, under the immigration ordinance, the director of immigration and the chief executive have tools at their disposal. For someone not conducive to public good, it's a public interest ground, and such grounds include national security. If there is solid evidence and intelligence showing the non-permanent resident has received unlawful drilling overseas and that gives rise to national security risks, then the powers under the Immigration Ordinance can let the government bar such people from coming to Hong Kong, and that can neutralize or rather and address, mitigate the national security risks. So that should be enough to address the national security risks. So there's a balance that's struck here. No more questions? Chairman. 3 is about receiving, 4 is about providing training. Can we distinguish those two? So for someone receiving training overseas, there are other laws to deal with those cases. But let's look at subclause 4. Jail terms up to 10 years. So this is a point for the government to consider. Just a suggestion. It's a related amendment, clause 131. Page 152 in the bundle. This is about repealing something under the Crimes Ordinance. Treason is in Part 1 of the Crimes Ordinance. Since we are moving the parts on treason to the new ordinance, so the entire part under the Crimes Ordinance can be repealed. We haven't got to another point, but something will also be repealed, and that is Part 2, Crimes against the Monarch. Incitement to disaffection will also be moved to the new ordinance, so we will also repeal the relevant parts under the Crimes Ordinance. Ms. Carmen Khan, before we get to Part 3, we're still at Part 2. Now, some provisions will be repealed under the Crimes Ordinance. As Mr. Tommy Chung raised a point, and we were talking about, we shouldn't let the part where a provision is found restrict the meaning of the provision or the operation of a provision. This means as long as there is unlawful drilling leading to insurrection, then the provisions can operate as intended. Are there provisions in other ordinances of Hong Kong that can highlight this principle? SJ, who will take the question, please? In statutory construction, paragraph numbering and the number of parts will not affect the effect of provisions, and that's a fundamental principle that's clear. So we can all rest assured about that. The law should be read as a whole. Mr. Stanley My concern is about repealing the provisions under Clause 131. When we repeal the provisions, are there discrepancies in what we are moving and what we are repealing? So we end up throwing out the baby along with the bathwater. We haven't had a detailed look. Well, this can warrant a general response, but if the member has particular examples in mind, maybe Mr. M can raise it. This is a very broad question. DS, please. When we looked at what to move to the new ordinance, we went through every single provision under parts 1 and 2 of the Crimes Ordinance. For provisions that should stay, we have moved them to the new ordinance. Mr. Stanley M. I haven't had a detailed look, but let's say clause 17 incite for being coercion to swear an oath. I don't see a corresponding part in the new ordinance to what we have in the crimes ordinance. DS, please. Mr. Ivan Leung, if I may assist. The unlawful oath. I refer members to the legislative brief. There's a footnote 19. For unlawful oath, this crime is outdated. We want to repeal it. As the Deputy Secretary was saying, Parts 1 and 2 of the Crimes Ordinance contain unnecessary parts, so we then decide to repeal it. Is it because that offense is covered by other offenses? We can invoke the offense of conspiracy to commit a crime to cover those offenses. To cover offenses, capital offenses. Those crimes can be covered by other offenses, conspiracy to commit a crime, etc. If there are no questions, let's move on. We're moving on to the next part. Part 3. Incitement to mutiny, insurrection, and disaffection. 15. Clause 15. Insurrection. If a person joins an armed force or be a part of an armed force that is in an armed conflict with a Chinese armed force. B. A person with intent to prejudice the situation of a Chinese armed force in an armed conflict assists an armed force that is in an armed conflict with a Chinese armed force or assists the government authority or organization to which that armed force belongs. C. A person initiates armed conflict against the Chinese armed force. Or D. A person with intent to endanger the sovereignty, unity, or territorial integrity of China or the public safety of the HKSAR as a whole, or being reckless as to whether the sovereignty, unity, or territorial integrity of China or the public safety of the HKSAR as a whole would be endangered, thus a violent act in the HKSAR, the person commits an offense and is liable on conviction on the indictment to life imprisonment. Questions, Mr. Tommy Cheung. Clause 15, subclause A. Joining an armed force or be part of an armed force in an armed conflict with a Chinese armed force. So we're talking about local armed forces that do not belong to the Chinese government. If not, how do we distinguish between treason and insurrection? The DS, please. Treason and insurrection have two different focuses. Treason is about external threat. Someone assists an external enemy to invade China. So that's treason. Now here we have insurrection. There's a gap. We need an offense to deal with serious internal unrest. We need to deal with actions that affect public order. So the focus here is on internal unrest And that's what the offense of insurrection is about. Clause 15, subclause B. The second kind of crime. Or assist the government authority or organization to which that armed force belongs. We're talking about a government that is not the Chinese government. Is this a renegade province? Does that include a renegade province? If not a renegade province, then how do we distinguish between treason and insurrection? We frame the provision broadly. To deal with different bodies in an armed conflict with the Chinese armed forces. The broad framing can cover the scenarios raised by Mr. Tommy Cheung. Chairman, I want to ask about the relationship between Clause 10 and Clause 15. First, Clause 10, treason. Clause 15, insurrection. Structurally and phrasing-wise, Clause 15 and 10 are similar. Clause 10, 1a, a Chinese citizen joining an outside armed force at war with China, and Clause 15, 1a, if a person joins an armed force or part of an unarmed force in armed conflict with the Chinese armed force. So where's the distinction? Treason is about a war with external enemies and not about internal unrest. Is that the case? As for S, please. Just then the DS said, Clause 10, treason, is about outside enemies. Here, insurrection is more about internal unrest. For treason, the offense targets Chinese citizens, Hong Kong residents of Chinese descent. But for insurrection, it targets everyone, not just Chinese citizens. So those two are the key distinctions. Mrs. Regina Ip. Thank you, Chairman. Insurrection is a new offense. We don't have it in our prevailing laws. More than 20 years ago, we did not have the offense of insurrection either. So, correct me if I'm wrong. We have defined Chinese armed forces. A Chinese armed force refers to the People's Liberation Army, the armed police of the PLA, and the militia. Now we have the garrison of the PLA in Hong Kong. So anyone in an armed conflict with the PLA's Hong Kong garrison can be caught. But for someone to be in an armed conflict with the armed police or militia in the mainland, they can also be caught. But then D says, D1, a person with intent to endanger the sovereignty, unity, or territorial integrity of China and the public safety of the HKSAR as a whole, so on and so forth. Being reckless and committing violence. July 21st, 2019, a mob ransacked Lechko. Is that insurrection? On January 6th, some years ago, a mob stormed the Capitol Hill building. They smashed buildings. They killed police officers. The charge in the U.S. was insurrection. Several hundreds were charged. Some people end up with jail terms of more than 10 years. Mrs. Regina is right.
Under Clause 15D, the Colour Revolution back in 2019 mentioned by Mr. Stanley would be covered. Now, the action falls short of a war. concerning the storming of the Legislative Council and also wanton vandalism and arsonry and on the streets. These fall short of the act of treason. So we would charge the offenders under insurrection. So Mrs. Regina Ip is right. Next, I still have some time left. For D, for example, on the 21st of July, if the mob storms the liaison office and vandalize the national emblem or even the chief executive's residence, would that be insurrection? Secretary. The parameter is whether the action endangers the sovereignty, unity, and territorial integrity of the country and endangers public safety. Now, the example quoted by Mrs. Regina Abe, vandalism of national emblem, that would undermine the sovereignty of the country. So that would be caught. Mr. Stanley Ng, we have clearly defined what a Chinese armed force is. So for those who attack agents or agencies under the security system, for example, the armed police, the police officers, and the police officers in the mainland, will that count? In Hong Kong, for those who besiege or surround police stations, will they also be caught? Two scenario questions. Now, we would apply the same yardstick. If you look at D, 1 and 2, we mentioned the public safety of the Hong Kong SAR as a whole. So besides endangering the sovereignty, unity, or territorial integrity of China, we also consider the public safety of the Hong Kong SAR as a whole. So if these scenarios affect public safety, they would count. In the mainland, if they attack any security agencies, that should count as insurrection as well. Well, we target insurrection within Hong Kong. If there is such criminal action in the mainland, they will have their own system to deal with it. There is also the national security law of the PRC in the mainland. So after attacking police officers in the mainland, if those offenders come to Hong Kong and do the same, how will we deal with it? Sorry, I beg your pardon. Clause 15b, prejudice the situation of a Chinese armed force. So Chinese armed force does not include the police system in mainland. Secretary. Now, Chinese armed force refers to armed police, militia, and the PRA. Militia, PRA, and the armed police. For the police, that doesn't count because they are not part of the armed police. So they won't form part of the Chinese armed force. Next, Mr. Chan Siu-Hong. Thank you, Chairman. Some clarification needed. Thanks to the explanation given by the Secretary, I understand more. The difference between Clause 10 and 15 is this. If you look at Clause 10, 1, ABC, they correspond to Clause 15's ABC. It's just about the extent or the seriousness of the situation. It falls short of a war, but there is conflicts between the armed forces. So it corresponds to the seriousness and the magnitude of the conflict. I understand that. Clause 15D doesn't apply in Clause 10. Clause 15 refers to internal conflicts. So I would focus on D. Scenarios are mentioned. For example, activities endangering the sovereignty, unity, or territorial integrity of China or the public safety of the Hong Kong SAR as a whole. And violent acts are conducted. So it is clear for the color revolution and the black letter violence, these two offenses will apply. So act of violence or violent act, it carries a maximum sentence of life imprisonment. So what about destroying public facilities, removing railings, or even storming the electrical to conduct vandalism? Are these violent acts? So whether the maximum sentence of life imprisonment or lesser punishments would be meted out, it depends on the severity of the action, right? Correct. Violent act has a wide range of seriousness. A punch is a violent act, and you can set somebody on fire, and that is also a violent act. The consequences of these violent acts vary greatly. Under the common law system, the maximum penalty is life imprisonment. For lesser offenses, the punishment would be less severe. Mr. Tommy Zhang, second round, 3 minutes. Chairman, just one more question. Comparing clause 10(1)(b) with clause 15(b). Clause 10(1)(b), the criminal act is prejudice the assist an enemy at war with China in war. Clause 15(b), assist an armed force that is in an armed conflict with a Chinese armed force or assist the government, authority, organization to which that armed force belongs. Now, I try to understand clause 15(b) with the assistance of 10(1)(b). Prejudice the situation or assist an enemy at war with China in a war. Does that correspond to the parts in 15(b)? Excluding the government, authority, or organization to which that armed force belongs. Or if armed force includes militia, guerrilla forces, and regular forces, so shouldn't it also cover the authority, government, organization to which those militias and so on belongs? Deputy Secretary. Now the term an enemy at war with China in a war, there is a broad definition in clause 10. It includes a government of a foreign country or external armed force that is at war with China. So this is a broad umbrella term which covers all the entities, external entities at war with China mentioned by Mr. Tommy Zhang. These are all covered. Dr. Lo Wai Kwok, this is your first round. Yes, my first round for part 3, 4 minutes. Chairman, clause 15(d). It clearly spells out that if you endanger the public safety of the Hong Kong SAR or are being reckless as to whether public safety of the Hong Kong SAR would be endangered with intent, then you would be guilty, and the maximum sentence is life imprisonment. Now, violent acts which endanger the public safety of the Hong Kong SAR. Riots also endangers the public safety of the Hong Kong SAR. So how do we draw the line? What acts are rioting and what acts are insurrection? Now, for riots, the maximum sentence is 10 years. For insurrection, the maximum penalty is life imprisonment. For riots, it doesn't necessarily correlate to national security. These may be violent acts on the streets. They may fall short of affecting the sovereignty or public safety of the Hong Kong SAR as a whole. Say these may be localized riot acts, and they may not pose a risk to public safety to the entire territory. As I said, security in Hong Kong equates to security in the country. Thank you. Next, Mr. Lai Tong Kwok, 4 minutes. Thank you. Clause 15D 1 and 2. The reference to the public safety of the Hong Kong SAR as a whole. The term public safety is mentioned in many ordinances. Now, this time you add the clause as a whole. So, how wide is the coverage? When will you say an action is causing risk to the public safety of the territory as a whole? And second, there must be the elements of a violent act. Comparing with Clause 10, treason, there is a similar provision. Clause 10, 1E. Uses force or threatens to use force. So between treason and insurrection, there are two levels of actions. Clause 15, violent acts. Clause 10, force. So how do you draw the line? What actions count towards using force and what actions count towards violent acts? Secretary, thank you. The first question, what does it mean by public safety of Hong Kong as a whole? Now, it doesn't correspond to an individual place or instance. Let me take the 2019 Color Revolution as an example. Blossoming in 5 districts and so on. So you need to consider the totality of the actions, whether it causes an impact on the entire territory. So there are numerous examples. Let's say if there is a localized violent incident caused by labor disputes, then that doesn't count as insurrection. The point is, the entire territory or multiple districts will be affected by the action. Next, Mrs. Regina Ip, BC member, 3 minutes. Sorry, Chairman. What about the difference between violence and force? I will attempt to answer this question, and I will ask my colleagues to assist me. Ms. Daphne Siu. Thank you, Chairman. Please switch on Ms. Daphne Siu's microphone. Yes, concerning Mr. Lai's question, violence and force, they carry similar meanings. We make a distinction between them under Clause 15D and Clause 10D. Now, Clause 15A, the focus is a Chinese national. Such actions committed by a Chinese national would amount to treason. For Clause 15D, it corresponds to a person, and the locality is restricted to the Hong Kong SAR. So that's the major difference. Pardon, Chairman. So violent acts and force, these two terms are interchangeable. Ms. Stephanie Siu or the Law Drafting Division? In drafting Clause 10, we use the term uses force or threatens to use force. That's model upon Section 2, treason under the Crimes Ordinance. It goes by force. Now in Clause 15, we can't say an act of force. So in that context, we think for semantic purposes, we would use the term violence act. Mrs. Regina Ip, second round. Chairman, I'm not too concerned about the difference between violence and force. As mentioned by the law officer, violence act refers to an action, and also you would first refer to the ordinary meaning when interpreting the two terms. Violence and force, you can find the difference in any dictionary. Now, to follow up on Mr. Stanley Ng's question, the only Chinese armed force in Hong Kong is the PRA. That's the only one in Hong Kong. Do we have police officers from the mainland or the public security personnel from the mainland in Hong Kong? There are. They are in the co-location zone in West Kowloon. So if anyone attacks them, they will be dealt with by way of the mainland law. Correct. The jurisdiction in West Kowloon is under the management of the Chinese authority. So if a person attacks a police officer, we can resort to the public order ordinance and the crimes ordinance. We don't have to rely on the safeguarding national security ordinance. Thank you very much, Mrs. Regina Ip. Next, Ms. Carmen Can, 4 minutes. Thank you, Chairman. Clause 15A. A person joins an armed force. Regardless of the location of the armed force, as long as the armed force is engaging in an armed conflict with a Chinese armed force, that armed force will be caught. Is that the case? Deputy Secretary, thank you. The armed force engaging in an armed conflict with a Chinese armed force, we haven't specified the location of that armed force, so we are drafting it rather broadly. Thank you. That's what I want to ask. There is no definition, there's no specification about the location of the armed force. As long as it is engaging in an armed conflict with a Chinese armed force, it counts. Now, Clause 15D. A person with intent to endanger the sovereignty, unity, or territorial integrity of China or the public safety of the Hong Kong SAR as a whole. With this premise, when we interpret violent act, the meaning is different from ordinary one. There is a clear intent. That's why the violent act would be caught under this piece of important legislation. There are views considering that the scope of subclause D is too broad. Now, the burden of proof of the intent to endanger the sovereignty, unity, and territorial integrity of China will rest upon the prosecution. Unlike the example mentioned by the Secretary, blossoming everywhere in Hong Kong, that would affect the public safety of the Hong Kong SAR as a whole. So in deciding whether the scope is too broad, we have to understand this important premise. That's my view. Your understanding is correct. Any follow-up question? Thank you.
Next, Mr. Tommy Zhang. Third round, 2 minutes, questions and answers, please. No, I don't need that. I think my question has been answered. Right, let's move on to the next clause. Next one, extraterritorial effect of this decision. Clause 16, subclause 1. If any HKSAR resident who is a Chinese citizen body corporate that is incorporated, formed, or registered in the HKSAR, or body of persons, whether corporate or unincorporated, that has a place of business in the HKSAR, does an act outside the HKSAR, and the act would have constituted an offense under Section 15 had it been done in the HKSAR. That is the offense of insurrection in Clause 15. The resident or body commits the offense. Similar to other extraterritorial provisions, we provide a definition of HKSAR resident. Reverend Kuhn. Body corporate or body of persons, who should be liable then? I'll try to take this question. Thank you, Reverend Kuhn, for the question. Say, if this body of persons is a corporate, which has a separate legal status, then of course it's the corporate that should be liable. The individuals in that corporate, such as the directors, will not automatically be held criminally liable. In the case of an unincorporated, that is the structure of this body being very loose, we will consider members of this body, and then we'll consider the culpability of each individual of this body. You have a follow-up question? Sorry, I don't quite understand. According to the administration, the director of a corporate will not be automatically held liable. So who should be liable? Say, of course, in order to form a body, there must be individuals. And will the individuals be liable? Now, let me use the example of a corporate or a company. In a criminal law system, if the company is in breach of the law, then it's the company who gets fined. It is a separate legal entity that can be held criminally liable. As for whether the director of this company will also be held criminally liable, this will be dealt with according to the criminal procedures. According to the Criminal Procedures Ordinance, there is this provision. Let's say if this company is in breach of the law within the knowledge of the director, or that the director connives to the commission of the offense or condones the commission of the offense, then the director is also liable. But it doesn't mean that the director is automatically liable. Consent connivance, that's the expression used. Ms. Siu, you want to supplement? Yes, a Reverend Kuhn asked about an unincorporated body of persons. Now, for an unincorporated body, we need to consider the nature of this body. It comes in various forms. Say, in a partnership situation, the partners will be liable. So we need to consider, first of all, the nature of this body in order to find out the responsible person. Say, if it's a body registered with the society's ordinance, it will be dealt with accordingly. And say, in the situation of a partnership, the partners will each be responsible. Mrs. Regina Ip. Clause 16, extraterritorial effect of this division. HKSAR resident who is a Chinese citizen. Say, what if an HKSAR resident is not a Chinese citizen, and if they then attack the PLA in Hong Kong? Of course, this will be subject to the laws of Hong Kong in the jurisdiction. And if this resident who is not a Chinese citizen attacks the army the PLA in the mainland, then this law doesn't apply. There is no extraterritorial effect. True. So that means a Hong Kong SAR resident who is not a Chinese citizen can join an armed force and then wage a war against the mainland, and that this provision does not have jurisdiction over this person outside of the territory. That's true. Mr. Lai Tong Kwok. Clause 16(1), Roman numeral 2, body corporate that is incorporated, etc. So if this act is committed within the territory of Hong Kong, then if this act constitutes a crime, then it is liable. And then I look at the penalty. The penalty is only an imprisonment term, but you cannot imprison a body corporate. Is that right? So in other words, you need to go after a member of that body corporate that is a natural person. Is that the case? How do you imprison a company? If I may assist, Chairman, I think I've given the answer already. Now, if a company is in breach of the law, the penalty is a fine. Now, in this bill, we provide the penalty clauses. Usually, it comes in the form of an imprisonment term, but it doesn't mean that the court may not impose a fine. This is according to the Criminal Procedures Ordinance, and the court has the power to impose a financial penalty. This approach is also consistent with the HKNSL. Article 31 of the HKNSL refers to body corporate that is incorporated formed, registered in Hong Kong, and if this body corporate is in breach of the law, a financial penalty may be imposed. So this is a consistent approach. So according to the Criminal Procedures Ordinance, the court can impose a fine on the body corporate. Ms. Carmen Kan. May I ask for a further explanation on HKSAR resident who is a Chinese citizen? Dual nationality is not recognized by our country. So whether you're a permanent resident in the Hong Kong SAR or you're just somebody without right of abode in Hong Kong, as long as you are an HKSAR resident, if you are a Chinese citizen committing an act outside of the territory, and by an act I mean joining an armed force, etc., to be engaged in a conflict with a Chinese armed force, so on and so forth, then this person is still committing an offense. I think for the public's sake, you should make it clear. Yes, your understanding is correct. Any follow-up? No. Division 2, Part 3, Clause 17, please. Chairman, Clause 17, incitement of members of Chinese armed force to mutiny. Subclause 1, a person who knowingly incites a member of a Chinese armed force, A, to abandon the duties and abandon the allegiance to China, or B, to organize, initiate, or participate in a mutiny, commits an offense and is liable on conviction on indictment to life imprisonment. Subclause 2, in this section, and then there is a definition of certain terms. Mutiny means an act done by two or more persons who are, or at least two of whom are, members of a Chinese armed force. And then A, to overthrow the lawful authority in a Chinese armed force or in an army or force of a government or organization of a foreign country that is acting in cooperation with a Chinese armed force, or B, to resist such lawful authority in such a manner as to substantially prejudice the operation efficiency of a Chinese armed force or of of a part of an army or force of a government or organization of a foreign country that is acting in cooperation with a Chinese armed force. Questions? Mr. Kitson Yang. 17(1)(a). I have a question. I see in subsequent provisions the same description to abandon the duties and abandon the allegiance to China. Can you explain about this expression? What if somebody incites the personnel to abandon the duties but not to abandon the allegiance to China? Then will it be caught by this provision? Can you explain how this is drafted? Do allow me, Chairman. Incitement of members of Chinese armed force to mutiny. This is a very serious offense. As you can see in the penalty clause, the maximum offense is, the maximum penalty is life imprisonment. So what is exactly is described here? If somebody abandons the duties and abandons the allegiance to China, then it is not as serious. The point is, if this happens, both happen at the same time, involving a member of a Chinese armed force, then this becomes something very serious, and this is reflected by the level of penalty. Next, Mr. Holden Chow. 17(1). A person who knowingly incites a member of a Chinese armed force to abandon the duties and abandon the allegiance to China. Knowingly, my question is on this term. What knowledge are you referring to? Inciting a member of a Chinese armed force to abandon the duties. Well, the intention is crystal clear. If you want to incite a member of a Chinese armed force, you come with a very clear intention. Then why is it that the person who must knowingly incite so and so? Because if you include the word knowledge, it means that the person must possess knowledge of a certain thing. Do you mean that by inciting this member of a Chinese armed force, you know that the effect is that this armed force will abandon the duties? Or what kind of knowledge are you referring to? Or is it something like this? You have knowledge that this is a member of a Chinese armed force and you continue to practice incitement, then and that if you have no knowledge that this person actually is a member of a Chinese armed force, then you won't be caught. I want you to explain what knowingly or knowledge here means. Yes. I'll try to take this question first. If need be, my colleagues can supplement. If we take a look at the English text, it will be clear. Knowingly incites, that's the term. This person knows what he's doing, regardless of the means. This person knows that the action is one of incitement. He is inciting a member of a Chinese armed force. We categorically provide the word knowingly so as to express the need for mens rea. DOJ? Let me supplement. This term knowingly refers to this person having knowledge of who this person is being incited. That is a member of a Chinese armed force. And because for every Chinese citizen, there is a natural duty for them to pledge allegiance to China. If I incite this person to abandon the allegiance to China, without knowing that this is a member of a Chinese armed force, it doesn't constitute the offense. So we want to make sure that these elements are met. Well, that's exactly what I thought. Thank you. Mr. Tony Chair. Well, I think my question is similar to what Mr. Holden Chow just asked. I also want to know about this term knowingly. That means this person knows of the person's identity, and on this knowledge, you continue to incite this person. Anything else? No. Mr. Stanley Ng. I think I share the same concern of Mr. Holden Chow. Now we have a very clear answer, but I need to clarify a couple of things about mutiny. Why is it that the act should be done by 2 or more persons? What is the basis of prescribing 2 or more persons? Why can't one person practice mutiny? And then 2B, to resist such lawful authority, my understanding is the Chinese armed force as a lawful authority, because you put in the word such, and there could be different forms of authority or forces. And I'm not sure whether you should distinguish between lawful and unlawful authority. So why don't you just prescribe Chinese armed force instead of lawful authority? Let me take the first question. As for the second one, I didn't quite catch it. Perhaps I'll ask Mr. Ng to elaborate on it. On the first question on the definition of mutiny, I would invite members to refer to another piece of legislation. The definition does not exist in the Crimes Ordinance. During the consultation, the Hong Kong Bar Association has suggested providing a definition of mutiny. So for the Criminal Act in Australia, there is a similar explanation on mutiny. So this is modeled on the Australian provision. Now, if only one person who is a member of a Chinese armed force is involved, we should refer to 17(1)(b). That is an incitement offense. If you incite a member of a Chinese armed force to abandon the duties and abandon the allegiance to China, this already constitutes the offense of mutiny. Right, please repeat the second question. No, just to pick up on the last point, an act done by 2 or more persons. Well, you just answered that you made reference to an Australian act, but the act itself involves an incitement. Why is it that if the act is done by one person only, it does not constitute an offense? DOJ. Chairman, as I explained, if a member of a Chinese armed force is involved, that is committing the crime of insubordination, failing to obey orders from above, then this constitutes the act of abandoning duties and abandoning the allegiance to China. It is an incitement, and we believe that 17(1)(a) should suffice in handling this situation. SJ? Now for mutiny, I think we need to consider the verb as well, to organize, initiate, or participate in a mutiny. So if you organize something, it involves more than one. If you initiate a mutiny, more than one. And if you participate in a mutiny, again, more than one person. So that's the concept of mutiny. if we focus on the act of one individual, then at least it's 17(1)(a). So let's make it clear. He will not be let off. It's just a matter of which provision applies.
Can I get to my second question? I want to repeat my second question. It's about mutiny in B. To resist such lawful authority. Such lawful authority. There are many antecedents for lawful authority without a clear definition. So the reader is left unclear. So why not just say a Chinese armed force in subclause B under 2? Thank you, Chairman. Lawful authority has to do with paragraph A. Paragraph A refers to two authorities: a lawful authority in a Chinese armed force, or the force of a government or organization of a foreign country. So by such lawful authority, you're referring to what we see in paragraph A. Why not just spell out? Just say lawful authority in paragraph A. There is just one antecedent, paragraph A. There is no reference to any other lawful authority. So by saying such lawful authority, the phrasing there is clear enough. It refers to paragraph A. Moving on to clause 18. Assisting members of Chinese armed force to abandon duties or absent without leave. Subclause 1. A person commits an offense and is liable on conviction on indictment to imprisonment for 7 years if the person, knowing that a member of a Chinese armed force is about to abandon the duties or absent himself or herself without leave, assists a member in doing so. Subclause 2. A person commits an offense and is liable on conviction on indictment to imprisonment for 10 years if the person, knowing that a member of a Chinese armed force is about to abandon the duties or absent himself or herself without leave, colludes with an external force to assist the member in doing. Subclause 3. A person who, knowing that a member of a Chinese armed force has abandoned the duties or has absented himself or herself without leave. A. Conceals the member. B. Assists the member in concealing himself or herself. Or A. Conceals the member. B. Assists the member in concealing himself or herself. Or C. Assists the member in escaping from lawful custody. Commits an offense and is liable on conviction on indictment to imprisonment for 7 years. And subclause 4, a person who, knowing that a member of a Chinese armed force has abandoned the duties or has absented himself or herself without leave, colludes with an external force to A. Conceal the member. B. Assist the member in concealing himself or herself. Or C. Assist the member in escaping from lawful custody, commits an offense and is liable on conviction on indictment to imprisonment for 10 years. Questions, Mr. Kitson-Yang. Clause 18, subclause 1. Under treason, there's a requirement to disclose the commission of treason. So someone comes across the fact that someone else is trying to absent himself or herself without leave. Is there an offense for those who fail to disclose knowledge of this kind of offense? No, we target those assisting someone to abandon duties. So staying silent is fine. That's an offense only in the context of treason. Mr. Chen Xiuhong. I have a similar question. So someone knows that a member of a Chinese armed force will give up duties or go AWOL. There should be a duty to disclose the knowledge. Otherwise, there may be some form of assistance. I don't quite get the point from the S4S. There should be a duty. You know someone from an armed force, you know this member is about to abandon the duty or go AWOL. Who should a person with such knowledge report to? So staying silent will not constitute an offense. Can the government clarify this point? That's the legislative intent. It's about proportionality. In treason, we make it an offense to fail to disclose such knowledge because treason is a grave offense. But we have to strike a balance when other offenses are at play. Murder is important, for example, but we don't have an offense for the failure to disclose information about the knowledge of someone else about to commit murder. Next, Mr. Stanley Ng. Clause 18, subclause 3C. 3C. Assists the member in escaping from lawful custody. The penalty level here, is it lighter or heavier than the penalties for helping a prisoner escape? If the penalty is lighter, then the question is, why have a lighter sentence? If it's stiffer, then that only makes sense. As for us, we need to look up the information before giving a response. Any other questions? No. Ms. Carmen Khan. Thank you. Clause 18, bracket 1. It's about knowing. Clause 17, subclause 1, knowingly incite. Is there a difference in the extent? Is there a different shade of meaning at work? So difference between knowing under clause 18 and knowingly incite under clause 17. Who will take the question, please? I will take this question. Clause 17, the focus is on incitement. Clause 18, the focus is on assistance. There's a difference between incitement and assistance. So there are different penalties. For incitement, the penalty can be up to life imprisonment, but for assistance, the penalty will be 7 to 10 years in jail. Now, in English, they look similar. The phrases look similar, knowing, knowingly. I don't see any real difference. Wouldn't it make more sense to align the wording in drafting? Knowingly is in line with the language under the Crimes Ordinance. We can look at that again, but that's how I see it. I could be wrong, but I thought knowingly is actual knowledge. And knowing will cover ought to know, reasonable grounds for believing, etc. So is there a distinction in the state of knowledge? Knowledge refers to actual knowledge. So can you look at ways and whether we can align the wording? Now, constructive knowledge, reasonable grounds for belief. We spell that out separately in other ordinances when the distinction matters between actual and constructive knowledge in criminal law. So here, knowingly, they refer broadly to actual knowledge. So that clears up the question for Ms. Carmen Khan. Thank you for your guidance, Chairman. In Chinese, 明知 and the Chinese term for 知識, the wording is different, but in English, it's knowing, knowingly. So as the Chairman suggested, let's consider whether we can align the wording and whether we can improve the phrasing. But it's worth putting on the record that knowing and knowingly are the same. Actual knowledge covers the cases of both 17 and 18. We're not saying that 17.1 is a more serious case. Now, Clause 17, subclause 1, to abandon the duties and abandon the allegiance to China. Incitement to mutiny is a grave offense that carries life imprisonment. So we need two conditions to be there. Whereas assistance for someone to abandon duties, it's a different offense. We don't need an element for abandoning duties and abandoning allegiance. Any response? Now on the sentencing. 10 years for incitement to abandoning duties and allegiance. Ms. Carmen Khan is right on the point about having two elements. Now, let's look at the prison's ordinance. For helping a prisoner to escape custody, the maximum sentence is 2 years. But here, the maximum sentence is 7 years. Any response from other officials? No? Mr. Tony Tse speaking for the second round. The first round, actually. I want to clarify a point, Clause 18.3c and 4c. Escaping from lawful custody. What if it's bail? Is that custody? Or being on the wanted list, does that count as custody? Custody means it's a lawful form of detention. But when someone's on the wanted list, this may refer to someone hiding. Other questions? Chairman. So when someone's in hiding after escaping, so what are we looking at? Escaping means it's escaping from lawful custody. While this person is in lawful custody, the person escapes. If the person is on bail or on the surety, on a bond, then this person is in hiding. The hiding can take place in different places. So that's for hiding. All clear. Thank you. No other questions. Let's move on to Clause 19. Inciting disaffection of public officers. Subclause 1. A person commits an offense and is liable on conviction or indictment to imprisonment for 7 years if the person knowingly incites a public officer to abandon upholding the basic law and abandon the allegiance to the HKSAR. Subclause 2. A person commits an offense and is liable on conviction on indictment to imprisonment for 10 years if the person colludes with an external force to knowingly incite a public officer to abandon upholding the basic law and abandon the allegiance to the HKSAR. In this section, public officer means A. A person holding an office of emolument under the government, whether such of office be permanent or temporary. B. Any of the following persons, if the person is not a person mentioned in paragraph A. 1. A principal official of the government appointed in accordance with the Basic Law. 2. The monitoring authority appointed under Section 5A of the Exchange Fund Operation, or a person appointed under that ordinance. 3. The chairman of the Public Service Commission. 4. A staff member of the Independent Commission Against Corruption. 5. The Ombudsman, or a person appointed under the Ombudsman Ordinance. 6. The Privacy Commissioner for Personal Data, or a person employed or engaged by the Commissioner under the Personal Data Privacy Ordinance. 7. The chairperson, or a member of the Equal Opportunities Commission, or a person employed or engaged by the Commission under the Sex Discrimination Ordinance. 8. A judicial officer or staff member of the judiciary. C. A member of the Executive Council. D. A member of the Legislative Council. E. A member of a district council. Or F. A member of the election committee as defined by the Chief Executive Election Ordinance. That's all from me, Chairman. Questions? Dr. Kennedy Wong. Thank you. There are different kinds of public officers. I want to clarify a point. 3B2. Does that cover the CEO or chairman of the Securities and Futures Commission? In finance, the SFC is a key player. There are other public offices. There are public bodies, such as the Airport Authority. It's a major asset of the government. It's also a key piece of infrastructure. So can the government tell us the reasons for having some categories here but not others on the list? The DS, please. Just then, Dr. Kennedy Wong asked about the extent to which we set out the list. Now, on what's on the list, these are people who play a key role in the government, or like the Ombudsman, the Privacy Commissioner for Personal Data, and the EOC's chairperson. These three bodies have investigative powers, and during investigation, these people come across government information. When these people are subject to incitement that will affect government operation. We have also thought about whether to broaden the scope to enhance the protection. If we go very far, then for those people, and some of these people are not in a paid position, we're talking about abandoning allegiance to the HKSAR or the Basic Law. Let's think about this. Say a family member tells a person to abandon the job. So if we include those positions on the list, so there's a worry. Potential candidates for advisory bodies may hesitate. So we take this approach, as you see on the bill instead. We only include on the list people with a role that will directly affect government operation. So that's our thinking. Chairman, I mentioned the SFC in particular. The government's response from the DS said that some of these roles have investigative powers or prosecution powers. The same goes for the SFC, so why not the SFC? Chairman, the investigative powers of these three bodies mean they can access government information from departments. These roles have access to confidential government information. So when we look at the impact on government operation, it's appropriate to include just these three roles. And that's more important than including on the list other advisory bodies. That's why we have them here. Chairman, I also asked statutory bodies, Airport Authority. Why not put that on the list? Chairman, it's the same principle. We consider whether the impact on the government would be serious if incitement were to occur. So the consequences of incitement for people in those roles are different from incitement of people in the roles on the list. But the Airport Authority and the SFC are not advisory bodies. They are statutory bodies. The Airport Authority and the SFC are in charge of their respective areas that are vitally important. But I guess that's fine. Mr. Gary Chen. Can I clarify a point? Some civil servants told me about their worries. They retire, they want to emigrate to a certain place, live overseas with another civil servant who will retire later. So a retiring civil servant asks another civil servant who will retire later to live abroad. They wonder whether that counts as inciting disaffection. I assure the civil servant, but they are not convinced. So can I take this opportunity to ask for a clarification? Now I turn to the question about the EOC. It covers the chairman, the chairperson, and the staff members. But why are we just including the chairperson of the Public Service Commission without covering the members? Why the discrepancy?
Thank you. On the first part, the incitement we are talking about is inciting abandonment of allegiance to the Hong Kong SAR and the upholding of the basic law. Now, retirement plan is a very personal thing. Career and life planning is very different from upholding the basic law and pledging allegiance to the Hong Kong SAR. Deputy Secretary, the chairman of the Public Service Commission is a position with emolument. It is different from other members of the PSC. Now, I think the first question is very important. The point is how we interpret the term abandoning the allegiance to the Hong Kong SAR and upholding the basic law. Now, some people may think that by giving up your positions in the government, you are abandoning your allegiance to the Hong Kong SAR. Now, I refer you to Section 3AA. There is a very detailed list listing out what actions constitute to the abandonment of upholding the basic law and allegiance to the Hong Kong SAR. For example, if you support the carving out of Hong Kong from China, and if you support Hong Kong independence, that would count as an act of abandoning the allegiance to the Hong Kong SAR. So I refer you to the provision. By leaving the government, you don't have to worry. So please trust our explanation. Mrs. Regina Ip, Chairman, I share the same view with Dr. Kennedy Wong. The SFC or even the Hong Kong EX, these bodies have investigative powers. These are important financial bodies, so I am perplexed why they were left out and only the HKMA is here. I thank the Secretary for Justice for his explanation. For a electrical member or even a district council member, for any personal reason, say health reason, a friend advised me to give up my position in the electrical or the district council. Does that amount to inciting disaffection? Mr. Paul Lam has answered us. I also refer you to Cap 1. There is the positive and the negative list on what constitutes allegiance or abandonment. Now, if you advise a district council member to give birth and get the $20,000 newborn baby bonus, and you should leave the position, that doesn't amount to inciting disaffection. So the real question is why only HKMA is included. Allow me. We adopted a risk-based approach in drafting the law. We assess the risk that upon incitement of disaffection, whether the consequence would be significant. So we took a risk-based approach. It's now my turn. My first question relates to Dr. Kennedy Wong's question. A person holding an office of emolument under the government. Under the government, does that mean subvented schools, public bodies, advisory bodies, and so on? I think you have answered my question. But still, I have some concerns. The HAA and the SFC, these two bodies perform very important societal functions. One is regulatory body, the other is the body managing our airports. So I'm quite surprised why they are being left out. But I know you have your own considerations. I think these two bodies are very important to the overall governance and operation of the government. So that's my comment. Second, why are the official members of the EAC are also covered under the term public officer? I mean the member of the election committee. A member of the election committee has the right to vote for the chief executive. The risk pertaining to this position is high. That's why we are also including member of the election committee. Mr. Stanley Ng. Chairman, I agree with you. I also wonder why some statutory bodies were left out. Bodies like the hospital authority, it is also an important body. So that's just my view. Concerning the scope of coverage of the term public officer, point F, member of the election committee, besides chief executive election, the members of the election committee can also vote in Legislative Council members' election or even Hong Kong deputies to the NPC. On the district council level, we also have the 3 committee members. Shouldn't the members of the 3 committees be covered as well? Security Bureau. Mr. Stanley mentioned the 3 committees. Now it also boils down to the extent or significance of risk. Now the 3 committees, they are the fire safety committees, the crime committees, and area committees. So we think, considering the extent of the risk pertaining, it is suitable to leave them out. Ms. Carmen Kan. I share the same view. Me included, I'm the 5th member pointing the same. Dr. Kennedy Wong, Mr. Stanley Ng, Mrs. Regina Ip, you and myself have also raised these questions. Now, as a public officer, they are potential targets of incitements of disaffection. So we have to assess the risk of being incited to disaffection and also the risk to national security. HAMA, SFC, chairman of the SFC, chairman of the HAAA, and also the chairman of the hospital authority, the chief executive. Well, let's not forget, in the parts of state secrets, the same definition for public officer applies. It seems the main focus now is whether the office comes with emoluments. As the Secretary mentioned, the chairman of the Public Service Commission is included because it is an office of emoluments. Now, we also have the chairperson or member of the Equal Opportunities Commission, the Privacy Commissioner for Personal Data, and the Ombudsman. It seems that the criteria is emolument. Now, the chairman of the SFC, the chief executive of the chairperson of the HAAA, it seems that these are not officers of emolument. But you have to look at the risk to national security when these people are being incited. The line of work is closely related to state secrets. So maybe we should add a subclause G that, depending on the circumstances, the chief executive in council may amend the definition of public officer. The major concern is not whether it is an office with emolument. It is about the significance to the operation of the government, the society, and whether public power is being exercised. That should be the most important concern. Please answer Ms. Carmen Khan's question. I agree with Ms. Carmen Khan. Emolument or not is not the major concern. It's about the risks to our overall public safety. I also agree with Ms. Carmen Khan that where necessary, we can amend the definition of public officer through subsidiary legislation. With developments in society, the risks are ever-changing as well. So the definition, the list of public officer is subject to changes. Allow me to state my opinion. In selecting and appointing these important public officers, as you said, the SFC, the HAAA, these are bodies affecting the daily operation of society. Even if they fall outside the definition of public officer, you should consider them as well. Now in English it says whether they are upholding the basic law and whether they pledge allegiance to the HASAR. These are important considerations. So these should also be the factors you consider. Secretary, I agree. You mentioned amending the term by way of subsidiary legislation. Actually, you should put the definition of public officer on a schedule. That would make it easier for you to amend. If you set out the definition by way of a schedule or an annex, it would be easier for you to amend it. We will study it after the meeting. Mr. Jeffrey Lam. Thank you, Chairman. First of all, I agree with the Chairman and Ms. Carmen Khan on the definition of public officer. We should look beyond whether the office comes with an emolument. My observation is this. On the list, ICAC, Ombudsman, they serve a particular function. They have investigative powers. Same goes for SFC, not so much for the Airports Authority. So is this also a criteria? As I said, we consider a range of factors, whether it comes with an emolument, the extent of public power, whether the position comes with access to government's secrets, and also the significance or consequences of such people upholding the basic law and allegiance to the HASAR, as well as the impacts on public safety. I mentioned investigative powers because it would have an impact on other departments and also the private sector. Some are even empowered with prosecutorial power. So that's my suggestion. Next, Ms. Carmen Khan, second round, 3 minutes. Chair, a very brief question. What about the Director of Audit? Does Director of Audit count? Does that office fall under Part A? Yes, Director of Audit is a principal official, so the position falls within the definition of A. Let's move on. Clause 20. Thank you, Chairman. In citing the disaffection of personnel of offices of central authorities in Hong Kong, 1. A person commits an offence and is liable on conviction or indictment to imprisonment for 7 years if the person knowingly incites any of the personnel of any of the following offices of the central authorities in Hong Kong to abandon the duties and abandon the allegiance to China. A. The Liaison Office of the Central People's Government in the Hong Kong SAR. B. The Office for Safeguarding National Security of the Central People's Government in the Hong Kong SAR. C. The Office of the Commissioner of the Ministry of Foreign Affairs of the People's Republic of China in the Hong Kong SAR. Subclause 2. A person commits an offence and is liable on conviction or indictment to imprisonment for 10 years if the person colludes with an external force to knowingly incite any of the personnel of a CA office in Hong Kong to abandon the duties and abandon the allegiance to China. Question. No. Clause 21. Possession of documents or articles of incitement nature with intent to commit specified offence. 1. A person commits an offence and is liable on conviction or indictment to imprisonment for 3 years if the person, with intent to commit a specified offence, possesses a document or other article of such a nature that the distribution of a document or article of that nature to a relevant officer would constitute the specified offence. In this section, specified offence means an offence under section 17, 19, or 20. Relevant officer means A. In relation to an offence under section 17, a member of a Chinese armed force. B. In relation to an offence under section 19, a public officer within the meaning of that section. C. In relation to an offence under section 20, any of the personnel of a CA office in Hong Kong within the meaning of that section. Question time. Mr. Tong Li Jie. Thank you, Chairman. I would like to understand that under the clause documents or other article, I think items and articles in electronic form are also covered. So if a person merely possesses these articles without distributing them, would the person be caught? What about possession of inciting articles? The provision specifies 2 elements: possession and also the distribution of the documents or article of that nature to a relevant officer. Only then would it constitute the specified offence. So there are 2 steps. First, possession, and second, distribution of the article. I invite Mr. Leung to supplement. By way of clarification, Chairman, Clause 21, the offence does not require proven distribution. Now, the act is first possession of the document or other article of such a nature. The second half of the clause means that if such articles or documents are distributed, it would constitute incitement to disaffection. So the mens rea pertains to the first sentence. A person commits an offence and is liable on conviction, and so on, with intent to commit a specified offence. So if there is an intention to commit the incitement to affection and you possess the article, you are already guilty. We don't have to prove that someone has distributed the article or document. So what about those documents in electronic form? And about your previous answer, I need to clarify it. Possession with an intent to commit the specified offence, meaning these articles or leaflets or documents. If someone receives these articles and out of curiosity, the person reads it but forgot to dispense of it, then the person may be caught by the law. There is a similar element in Clause 23. Simply possessing these documents would be in breach of the law? Which official? Mr. Leung, once again, I stress the term with intent to commit a specified offense. If someone receives such a document, then it would not constitute the offense in Clause 21. Dr. Kennedy Wong.
Chairman, further question on possession. It's common knowledge that very often we receive messages on our mobile phone from somebody unknown. If I forget to wipe it clean and if it's stored in my mobile phone, would it count as possession? Let me take this question. It is important to consider intention. Now, someone mentioned receiving an email from somebody anonymous, and if I don't open it and I don't have intention, then it's all right. The word intent or with intent are important. Possession of documents or articles of such a nature, so on and so forth, it's not hard to understand what possession of documents or articles, possession of documents mean. But what about articles? How can you tell whether it is an article of incitement nature? Do we need to give a clear definition? Article here refers to something other than a document. It could be, say, a sculpture or other articles. But what is important is that if this article is distributed to a relevant officer, it would constitute the specified offense. So there is an intention of incitement. Or some articles could be interpreted in different ways. So how do you make sure that how do you make sure that people will not be inadvertently caught by the law? Well, I don't think this will happen because, as I explained, we need to consider the intention is for the prosecution to prove beyond reasonable doubt the intention. That is to say, distributing this document or article will constitute an offense. Legal advisor. I have a question on Division 3, the offenses of incitement to mutiny, etc. There is a similar offense in the provisions of the current ordinance that will be repealed. In Section 7, Subsection 6 of Cap 200 Crimes Ordinance, if necessary, the Secretary for Justice will seek consent before proceeding with prosecution. And then Division 3, be it Clause 19 all the way to Clause 21, there is no such requirement of seeking approval. So the question to be asked is whether there is no requirement for the SJ's consent to initiate prosecution. There will be an umbrella provision applying to all the NS offences, echoing Article 41 of the HKNSL. A written consent from the SJ should be sought before initiating prosecution. So there is no specific provision for this offence. If there are no other questions, let's go to Division 4, Clause 22. seditious intention. Subclause 1. For the purposes of this division, a person does an act with a seditious intention if the person does the act with one or more of the intentions specified in subsection 2, and an act, word, or publication is an act, word, or publication that has a seditious intention if the act, word, or publication has one or more of the intentions specified in subsection 2, and then subsection 2, the intentions are as follows. A. An intention to bring a Chinese citizen, Hong Kong permanent resident, or a person in the HKSAR into hatred, contempt, or disaffection against the following system or institution. 1. The fundamental system of the state established by the Constitution of the People's Republic of China. 2. A state institution under the Constitution of the People's Republic of China. Or 3. The following offices of the central authorities in Hong Kong. A. The liaison office of the CPG in the HKSAR. B. The offense for safeguarding national security of the CPG in the Hong Kong SAR. C. The office of the Commissioner of the Ministry of Foreign Affairs of the PRC in HKSAR. Or D. The Hong Kong garrison of the Chinese People's Liberation Army. B. An intention to bring a Chinese citizen, Hong Kong permanent resident, or a person in the HKSAR into hatred, contempt, or disaffection against the constitutional order, executive, legislative, or judicial authority of the HKSAR. C. An intention to incite any person to attempt to procure the alteration otherwise by lawful means of 1. Any matter established in accordance with the law by the central authorities in relation to the HKSAR. 2. Any matter established in accordance with the law in the Hong Kong SAR. An intention to cause hatred, enmity amongst different classes of residents of the HKSAR or amongst residents of different regions of China. E. An intention to incite any other person to do a violent act. And then F. An intention to incite any person to do an act does not comply with the law of Hong Kong or does not obey with an order issued under the law of Hong Kong. 3. However, if a person doesn't act only with any of the intentions specified in subsection 4, the act is not done with a seditious intention. And B. If any act, word, or publication only has any of the intentions specified in subsection 4, the act, word, or publication is not an act, word, or publication that has a seditious intention. The intentions are set out in subsection 4a. An intention to give an opinion on the system or constitutional order mentioned in subsection 2a or b with a view to improving the system or constitutional order. B. An intention to point out an issue on a matter in respect of an institution or authority mentioned in subsection 2a or b with a view to giving an opinion on the improvement of the matter. And C. An intention to persuade any person to attempt to procure the operation by lawful means of 1. Any matter established in accordance with the law by central authorities in relation to the HKSAR. 2. Any matter established in accordance with the law in the Hong Kong SAR. D. An intention to point out the hatred and enmity amongst different classes of residents of the HKSAR or amongst residents of different regions of China is produced, or that there is a tendency for such hatred or enmity to be produced with a view to removing the hatred and enmity. I think we will pause here. We will move on to the second item now, and that is AOB, nothing under AOB. I'd like to inform members that at 2:30 this afternoon we will hold the 5th meeting, so do come back. Please refer to the notice. If there is nothing under AOB, then the meeting is adjourned. I'll see you at 2:30.